Reaching a mutual financial settlement is a major milestone for separating parties, but in family law, it is only the beginning of the legal process. A private contract holds no structural power to enforce financial remedies. Without a court order, settlements cannot be legally compelled if one party stops complying. To transform these promises into a binding reality, the agreement must become a consent order, a procedure governed strictly by Part 9 of the Family Procedure Rules 2010. Securing this order is not an automatic process. It requires absolute procedural compliance, mandatory financial disclosures, and rigorous structural drafting. We will break down exactly how to navigate this pathway, focusing on the Rule 9.26 Lodgement Bundle, the Form D88 Statement of Information, and the tripartite drafting architecture required by the Kiel precedents.
Mastering this formalized procedure is the only way to bridge the gap between an unenforceable promise and a final, unassailable legal reality. The process begins with Rule 9.26 of the FPR 2010. This rule sets out the strict requirements for lodging your documents, whether you are filing physically at a divorce center or utilizing the online portal. To avoid immediate rejection by the court, the application must contain a precisely configured lodgement bundle. The first mandatory requirement is the Notice of Application in Form A. You must also include 2 exact copies of the draft consent order. Signature requirements here are critical. The respondent must sign the draft order to formally demonstrate their consent to the terms. Additionally, the applicant or their legal representatives must sign the draft order if the document includes any undertakings. The final and most essential piece of the bundle is the Form D81, the Statement of Information. This form is mandatory. It must contain a signed statement of truth from both parties and explicit confirmation that they have viewed each other's full financial disclosures. Submitting an incomplete or improperly signed bundle halts the process before a judge ever sees it, resulting in lost time and increased client costs. A common misconception in family practice is that uncontested financial agreements are automatically approved. In reality, Section 33A of the Matrimonial Causes Act 1973 dictates a much more active role for the court. The judge is legally required to perform an inquisitorial review, actively interrogating the fairness of the proposed settlement, rather than simply signing off. The judge uses the Form D81 as a lens to assess the reality of the parties' financial positions against the specific division of assets proposed in the draft order. For an order to be approved, the judge must be satisfied that the terms are substantively fair in the context of all the circumstances of the case. If the D81 lacks detail, or if the division appears manifestly unfair without justification, the judge will reject the order and demand further evidence. The Form D81 serves as the essential evidentiary tool the judge relies upon to authorize the entire agreement. Effective drafting requires moving beyond the application forms and following the President's specific practice guidance for the order itself. Since May 2023, the Mr. Justice Peel Standard Family Orders have required a strict 3-part structural architecture. Part 1 establishes the definitions. This section provides the precise legal meaning of terms used throughout the document, leaving no room for ambiguity during future enforcement. Part 2 houses the recitals. This section contains declarations of fact and general agreements between the parties. Within the recitals, you will also find undertakings, solemn promises made directly to the court, not to the other party. These are necessary to cover settlement terms the court lacks the statutory power to order directly, such as promises to mitigate tax liabilities or obtain a religious get. Finally, Part 3 contains the actual orders. These are the enforceable financial mandates, such as lump sum payments and property adjustments. Mixing these categories, such as putting enforceable mandates in the recitals, creates a flawed document that is likely to be rejected or found unenforceable. Maintaining this structural integrity ensures the document is legally sound and ready for judicial approval. Drafting for success means anticipating the practicalities of post-divorce enforcement. Every clause must be precise. For lump sums, you must include strict time limits for payment and explicitly state the interest rates that will apply if those deadlines are missed. In mesher orders, where property remains in joint names, the draft must grant exclusive occupation to the resident party to legally prevent the other party from moving back into the home.
Practitioners should also use the Liberty to Apply clause correctly. It is limited to implementation and implementation guidance, not as a tool to vary substantive capital orders. This need for precision is especially acute in pension consent orders, which are governed by Rules 9.32 through 9.34. Before drafting begins, parties must exchange pension information to ensure all data is accurate and transparent. There is a specific procedural trap for pension attachment orders when no prior Form A was issued in the proceedings. In these cases, you must formally serve notice of the draft order on the pension trustees. The court will refuse to finalize the order until the trustees have been given a full 21-day window to raise any objections. Precision in these clauses prevents the settlement from failing at the point of implementation. The transition from a fragile private agreement to a robust court mandate is a complex procedural journey. Success depends on 3 pillars: compliance with the Rule 9.26 bundle, transparent disclosure in the Form D81, and the correct use of the tripartite Peel architecture. Remember that the judge is an active inquisitor under Section 33A of the MCA 1973. Surviving that scrutiny requires proactive, defensive drafting. Shortcuts on forms or structure lead inevitably to judicial rejection and higher costs for your client. Mastery of Part 9 FPR 2010 is the singular skill set that guarantees a negotiated financial settlement becomes a final, legally unassailable reality.